Okay, please be seated. Okay, Mr. Ng, you wanted to make a record.
Thank you, Your Honor. We would move for admission as a court exhibit the video of Colleen Fricke that you've, in your discretion, not allowed us to put it in. But I would like to, we object to your ruling, and I would like to make that a court exhibit, and I'll have Ms. Montgomery give it to your clerk. I assume without objection, just for the court's record.
Yes, we'll make it a court exhibit. Do you have a number? Okay. We do have it.
Oh, yeah. Okay. Well, then the second reason I wanted to take a moment of your time is that yesterday we had extensive discussions about the parameters of Rule 703, and the court ruled that we could not cross-examine Seth Stoughton on his opinion that Mr. Wright would be peacefully arrested in a short order. I'm paraphrasing, but that's the way I heard it anyway. And the court declined our effort to cross-examine him on specific instances where Mr. Wright failed to appear or would run away or escape and be difficult to find. And at the time, I asked to leave the court to make an offer of proof so the record is complete as to what we would have asked him about had we been able to do that. And we do object to your ruling in all due respect. But I do want to make an offer of proof. The offer of proof is that Mr. Wright has repeatedly failed to appear in court, therefore he was difficult to find. There have been bench warrants for his arrest in a number of cases for failing to appear. The cases are 27 CR 19, 20 754. The next case is 27 CR 19 22959. Next case is 27 CR 19-23184. Another one is 27 CR 19-23818. Another one is 27 CR 19-24205. The primary case that we're relying on is that only a month before his death, Mr. Wright was charged with a complaint of carrying a pistol without a permit. And the incident happened on June 30th of 2020 at 16:04 hours, according to the police reports. The police responded to, I'll just quote it, responded to a person with a gun call near 51st and Bryant Avenue North, Minneapolis, Hennepin County. The caller indicated that a light, complexed 17-year-old black male wearing black shirt and shorts and white shoes was waving a black handgun. The male then got into a white Toyota Camry occupied by 4 people, with the driver wearing a red shirt. Officers located the car nearby with a person defendant herein, Daunte Demetrius Wright, matching the person with the gun's description, sitting in the back seat. Once out of the vehicle, defendant took off running with officers in pursuit and managed to evade officers. Officers at the scene positively identified defendant from prior interactions. A loaded Ruger .45 caliber handgun matching the caller's description was found on the floor of the vehicle where the defendant had been sitting. Another occupant of the vehicle verified it was defendant's gun. Defendant does not have a permit to carry the firearm. This evidence would have been used in cross-examination to refute the expert's opinion that Mr. Wright would have been easily captured or found when his behavior in this instance was to run away. We have other instances of crimes of violence from him that would rebut Mr. Stoughton's thought that he was going to be peacefully arrested. He was charged, Mr. Wright was, with aggravated robbery in the first degree on December 4th, 2019. The case number is 27 CR 19-29850. That case was pending when he was stopped by Officer Lucky. And that again shows that he had a motive to flee to avoid arrest on that particular charge. The facts of that case are rather gruesome, and that is the one where he stayed overnight at a young woman's house and robbed her at gunpoint in the morning after that. This is recounted in my defendant's response to the state's memorandum in opposition to its pretrial motions. I incorporate by reference my brief, which outlines all the instances that I've referenced here. We also have instances of violence for Mr. Wright in that he's been charged in 2 civil complaints, one in 27 CV 216193, where he shot an individual in the leg and assaulted that individual's face and robbed him. And then there was another complaint where he shot someone in the head, and I believe that complaint is 27 CV 217390. And the reason we wanted this evidence in is that we needed to rebut the inference that Mr. Wright has been a peaceful individual, and we appreciate the loss of him by his family and the loss of anybody. But the image of him as being somehow law-abiding and in all ways terrific is undercut by some of his criminal behavior. And so to give the jury a fair image of him and a picture of the facts as we know them today, we would have cross-examined Mr. Stoughton on all of these, and he would have either admitted that he never saw any of it, and he should have, or if he saw it, it never got in his report. So that is the offer of proof, and again, we respectfully disagree with your ruling. I'm not here to grandstand, but I do want to make the record, and I have.
Okay. And you have made the record, and I stand by my original ruling. Any bad acts by Mr. Wright that Officer Potter was aware of, I allowed in, but she was not aware of all these other matters. The issue in this case is Officer Potter's mens rea, or state of mind, when she approached Daunte Wright at that stop. And logically, anything she knew about him would inform her decisions on how to approach him. These things were not within her knowledge. Okay. All right. Is there anything else we need to put on the record? Oh, one other thing. I'm going to finalize the jury instructions this afternoon, and when I get them done, I'll have Zach email them to you tonight. Okay, I should probably take about an hour. I do want you to know, just so you're thinking ahead, that I believe a definition of reasonable force that incorporates the definitions that the experts have acknowledged are controlling a reasonable officer, given the totality of the circumstances, something to that effect. I'll send it to you, and we can debate it tomorrow. I also want to alert you that I have thought about Mr. Ng's request for an additional instruction on authorized use of force, in addition to the authorized use of deadly force that both parties submitted. And I am going to allow an instruction to that effect because there's been so much discussion about this taser. Had the state not disputed Officer Potter's intended use of the taser, this wouldn't be a problem. But the state's expert was of the opinion that even a taser was not appropriate or reasonable under the circumstances. Obviously, the reasonable use of force instruction would only relate to the taser, not the gun. So it won't constitute a complete defense to the charge, because here a person was killed by a gun. So I just want to alert that issue, and if anybody has any comments about that now, I can hear them, or I can hear more detailed argument after you get the draft.
Draft, Your Honor.
Okay.
All right. Is there anything else we need to put on the record? All right. Thank you.